Title 3, Chapter 3, Duration and Effects of Penalties. Section 1, Duration of Penalties. Article 27 to Article 29 of Act Number 3815, Revised Penal Code of the Philippines. Article 27, Duration of Penalties. Reclusion perpetua. Any person sentenced to any of perpetual penalties shall be pardoned after undergoing the penalty for 30 years, unless such person, by reason of his conduct or some other serious cause, shall be considered by the Chief Executive as unworthy of pardon. Reclusion temporal. The penalty of reclusion temporal shall be from 12 years and 1 day to 20 years. Prisión mayor and temporal disqualification. The duration of penalties of prisión mayor and temporary disqualification shall be from 6 years and 1 day to 12 years, except when the penalty of disqualification is imposed as an accessory penalty, in which case its duration shall be that of the principal penalty. Prisión correccional, suspension, and destierro. The duration of penalties of prisión correccional, suspension, and destierro shall be from 6 months and 1 day to 6 years, except when suspension is imposed as an accessory penalty, in which case its duration shall be that of the principal penalty. Arresto mayor. The duration of the penalty of arresto mayor shall be from 1 month and 1 day to 6 months. Arresto menor. The duration of the penalty of arresto menor shall be from 1 day to 30 days. Bond to keep the peace. The bond to keep the peace shall be required to cover such period of time as the court may determine. Article 28. Computation of penalties. If the offender shall be in prison, the term of the duration of the temporary penalties shall be computed from the day on which the judgment of conviction shall have become final. If the offender be not in prison, the term of duration of the penalty consisting of the privation of liberty shall be computed from the day that the offender is placed at the disposal of the judicial authorities for the enforcement of the penalty. The duration of the other penalties shall be computed only from the day on which the defendant commences to serve his sentence. Article 29. Period of preventive imprisonment deducted from term of imprisonment. Offenders who have undergone preventive imprisonment shall be credited in the service of their sentence consisting of the privation of liberty, with the full time during which they have undergone preventive imprisonment if the detention prisoner agrees voluntarily in writing to abide by the same disciplinary rules imposed upon convicted prisoners, except in the following cases. 1. When they are recidivists or have been convicted previously twice or more times of any crime, and when upon being summoned for the execution of their sentence, they have failed to surrender voluntarily. If the detention prisoner does not agree to abide by the same disciplinary rules imposed upon convicted prisoners, he shall be credited in the service of his sentence with 4/5 of the time during which he has undergone preventive imprisonment, as amended by Republic Act 6127 of June 17, 1970. Whenever an accused has undergone preventive imprisonment for a period equal to or more than the possible maximum imprisonment of the offense charged to which he may be sentenced, and his case is not yet terminated, he shall be released immediately without prejudice to the continuation of the trial thereof or the proceeding on appeal, if the same is under review. In case the maximum penalty to which the accused may be sentenced is zero, he shall be released after 30 days of preventive imprisonment as amended by Executive Order Number 214 of July 10, 1988.